court beat, and I hope we learn a lot more about that. Abbie graduated from the University of California, Berkeley School of Law and has worked as a public defender in Washington State. She's a native of Indiana and has a degree in journalism from Northwestern. So even though several of the panelists are lawyers, this is not a panel of litigators analyzing the cases, although we'll talk about some of the cases. Our plan is to talk about the court as an institution and as a collection of individuals, and about how journalists cover the court. We will save some time for questions at the end, so you're free to start thinking about what you might want to ask. And I'll start with this question, which is that this term, we've had no deaths except for a retired justice, no retirements, no nomination hearings, no pandemics to disrupt the courthouse, no draft opinion in a major case leaked months before its official release, no surprise disclosures that some justices took luxury vacations at others' expense. Makes it sound like a boring term, except for the cases. David, you've been covering the court the longest. Has this been a boring term?
No, so I need to turn this on?
I think you do.
No, as usual, it's what's normal about the end of the term. It always seems like the grand finale at the 4th of July fireworks, you know, all the big bombs go off right at the end. The thing that, well, say just a general point about the court, and you said covering it as institution. It seems to me there's two ways to view the Supreme Court. There's what I call the John Roberts view, because he says it all the time, that we're a court of law, not politics. We're not Bush judges or Obama judges or Trump judges or Biden judges. We're and nonpartisan. We're not caught up in the partisanship of Washington. That's not what we do. We say what the law is. Then there's the other, what I'd call like the general American view of the Supreme Court. They asked the question, AP did a survey on this recently. How do you think the court decides its cases, based on the law or politics and personal ideology? And about seven out of 10 say it's politics. And then every so often you get a case that sort of tests that proposition. So this year we have a Republican president, former president, running for he's going to be the Republican nominee for president, is facing a criminal charge for essentially attempted insurrection brought by a Democratic president. So the case comes forward, the district judge says the case may proceed, the Court of Appeals said it may proceed, appeals to the Supreme Court. And Trump argues, I've got a sort of total immunity from prosecution. And lo and behold, on the last day of the term, it turns out all of the Republicans, with one notable exception, John Roberts and the Republicans agree that, well, gee, there's no presidential immunity in the Constitution. Nobody in the framers thought there was a presidential immunity. For 230 years, there wasn't but lo and behold, during the midst of this election year, this court finds a total immunity. The three Democrats dissent and say, my God, I fear for the democracy. This means the president could set up a bribery scheme in the White House, or Putin-like, he could have one of his aides shoot his political rivals, or order a military coup. And that's how the court term ends. And I thought, after I finished writing about it, I thought, you know, the guy, the 7 and 10 is going to say, see, I told you, I was right. So that's sort of a sad situation, but it seems to me that's the way a lot of people around the country will end up viewing this term.
Well, speaking of not having politics in the court, Ian Millhauser on Vox recently begged Justices Sotomayor and Kagan to resign now, so that they could be succeeded by two Democratic appointed justices, because with a Democratic majority in the Senate, it could be pushed through the way Gorsuch was, the way Barrett was pushed through. So David, do you think that's a good idea? And happy to get comments from everybody else.
I think it's a very bad idea, but get comments from everybody else. I'm interested if anybody else sees any merit to trying to push judges and justices into retiring long before they want to.
Mark?
Well, the thing about the call for Sotomayor and Kagan to retire is that they're a good bit younger than the justices whose retirements were sought, earlier. Ginsburg was in her 80s and, had previous bouts of cancer. Breyer was in his 80s and in good health, seemed to make a little more sense. But I know Sotomayor has diabetes, but the notion that the two of them, and Kagan in particular, who's, she's not even 65 yet. I mean, she can't even qualify for, well, I guess she can qualify for a full pension when she retires. But it's just the notion that either of them is going to do that on the prospect that Trump would be reelected seems ludicrous. And particularly since, I'm sure each of them thinks, well, I've got plenty of time left, even if Trump is reelected.
That's why CNN hasn't covered that story yet. If Biden is reelected, we may take another swing at it or another look at it. But I think in addition to what Mark said, I wasn't here for Ginsburg, but Sotomayor seems very sharp on the bench, and she's certainly sharp in her writings, and she's out and about. She's done a bunch of events this term where she took questions. I just don't know that it's a comparable situation. I think I understand why some of these groups on the left are anxious about it. But I don't really see, I don't really understand the timing of it just yet.
And I think Sonia Sotomayor, of all people, is keenly aware of what happened with Ruth Bader Ginsburg and sort of why Ian Millhiser is writing this. But I think she doesn't need someone to write a story to tell her why she should retire if she were so inclined.
So moving away, at least for a moment, from politics, COVID made some enormous changes in the court for a year or two. And the disruption of COVID, we hope, is behind us permanently. But it did leave some changes that have endured, at least when it comes to oral argument. Amy, can you tell us about that? And do you think they've been for the better?
So I think there are two major changes we can talk about. One of them definitely for the better, and that is the live audio of oral arguments. When the justices in May of 2020 went to telephone oral arguments, they, for the first time, started providing live audio because no one, including them, were in the courtroom of their oral arguments. And that was a big step for them. Previously, they had provided the audio of the oral arguments at the end of the same week. And so to provide the live audio was a big step for them, although it was sort of brought them into step with what many courts of appeals were doing already at the time. I remember before this happened, talking to people in the courts of appeals who were already doing it, and they'd say, basically you forget that there is live audio when you're in the courtroom holding an oral argument. And that certainly has proven to be the case, at least on the reporter's end. You sort of forget when you're sitting there listening to the oral arguments in the courtroom, because when they went back to the courtroom in 2022, if I remember that right, they continued the practice of providing the live audio. And, they had one little blip during the May 2020 arguments when there was the errant toilet flush in the background. They never figured out who the culprit was, and that's okay. But literally, I don't think you can point to any other issues with the live audio since then. I think there were concerns about the audio being misused somehow. That hasn't happened. I just think it's been a huge success for people to be able to listen to the oral arguments in real time when there are so few spaces in the courtroom, even if you're able to come to Washington, D.C. for oral arguments. I mean, the one flaw is that although they have now provide live audio of oral arguments, they do not provide live audio of their opinion announcements. I think particularly this term, when they were issuing all of these really important decisions, it would have been wonderful for the public to be able to hear the audio of these opinion announcements and the dissents in real time. But those opinion announcements are not available until the fall when the justices send them to the National Archives. So that's one development. The other development is, and many of you may be aware, when the justices started their phone arguments, they realized that having their sort of traditional free-for-all format when they couldn't see each other over the phone was going to be a recipe for disaster because they would be interrupting each other constantly. So they started what we sometimes refer to as the seriatim questioning, starting with the Chief Justice, going through to the Junior Justice in order of seniority. That proved to be something that Justice Thomas, who was not much of a talker at oral arguments, enjoyed. So when the justices returned to the courtroom, the other justices decided that it would be nice to have Justice Thomas continue to participate on a regular basis. So they continued the seriatim questioning by adding an opportunity for seriatim questioning to the end of the 30 minutes of oral argument that each side gets. The upshot of that is that it can sometimes make for extremely long arguments sometimes. So I went back and looked at some of the arguments this term, sort of the pair of cases involving regulation of social media in Florida and Texas, for example, went over 4 hours. I think that the presidential immunity argument was over 2 hours. And I think from the perspective of experienced advocates, I think the ones I've talked to really like it because they enjoy being able to stand there and know that there's sort of no stone is going to go left unturned. If a justice has a question, they will have an opportunity to answer it. From the justice's perspective, I think maybe they're a little bit torn. I think they all like having the chance to ask their questions, but I think there's sort of a tacit acknowledgement that in some cases this is going on a little bit too long. Sometimes on the days when there are 2 arguments, the second argument will be really, really short. They kind of run out of steam a little bit, but I think they like having it's kind of like, how you find people who say Congress is a mess, but I really like my member of Congress. And so I think like overall, they think the arguments are too long, but they don't want to give up their 5 minutes of questioning. So this is something that I think they'll probably continue for the near future. It's sort of on them unless they change the format to rein themselves in, and they really haven't shown any inclination to do so.
I suppose that means they're never going to go back to 4 arguments a day.
I mean, I don't think they don't have the docket they don't really even have the docket
For
right
2.
now for 2 arguments a day. So 4 arguments a day. As much as the lawyers who practice regularly before the Supreme Court would love 4 arguments a day, I think they'd take 2 at this point.
And I offer one reporter's view that's not exactly contrary to Amy, because I do think it's a great thing that the arguments are available. But from my selfish perspective, it's not nearly as much fun as it used to be covering arguments, because the more important the argument is, the less likely it is I'm going to be in the courtroom to actually see the argument, because we've got to report on it as it's happening. And with, increasingly we're doing live blogs for big argument cases. So it's not nearly as much fun. And then there's further on the selfish front, there's the idea that in the past, when AP would come down to report on what what had been said at argument, the kind of world was waiting to hear what had happened. And that's just not true anymore. I totally recognize the value of having the arguments live stream, but my job isn't as much fun as it used to be.
Yeah, I would second that, that it makes it more difficult to actually be in the courtroom and observe what's happening. And, that's largely though, because we can't bring in our laptops or phones, or we don't have any way to work quickly while we're in the courtroom. So they could, if they wanted, allow us to do our work while we're there. But it does make it so that we are oftentimes listening just like the public, to try to get stories out as quickly as possible. And we get to be in the courtroom less, or we will have more reporters, somebody working remotely and then someone in the courtroom just in case, so that we can catch big things that you might not be able to hear.
I saw Justice Gorsuch at a conference. He said, David, you don't come up to many of the arguments anymore. And I said, no, I really don't, because I need to write about them quickly. If you're in the courtroom, you you're just scribbling notes. I said, I always scribble notes and I can't read the hell what I wrote. I get downstairs and I can't read it. And I'm sort of starting afresh. So it's much easier for me to listen and type and get ready to. And he looked at me and he said, well, you're going to miss our facial expressions? And I said, yes, I'm willing to pass on the facial expressions.
You know, it would solve both of those problems, live video.
Yeah, I don't think that's going to be next.
I mentioned that one thing we didn't have this term was the premature release of a big opinion months before it was officially released. What we did have was a mini premature release in the Idaho emergency abortion case. Did that raise anybody's blood pressure on the panel? And did we figure out eventually what really happened? Abbie, you look like you're ready to say something.
Definitely raised the blood pressure. We don't find out, it's not like we have a heads up about which cases are coming. And so we have all of these cases and that any of them could come. And so I remember the night before that, I thought maybe abortion's coming tomorrow. So let me just go back through and, just in case. And then they released their opinions of the day and abortion was not among them. So I thought, okay, that's for, a later day. And then Bloomberg, reported that this draft opinion, at the time, we didn't know if it would actually be how they decided the case or not, had been briefly posted and then removed. And so then, of course, I think probably everybody on the panel was trying to find what the document was. Was it the actual opinion? What shape was the draft in? What was the vote count? What happened? So yeah, it definitely did. I was not around for the Dobbs leak. I imagine that was, the blood pressure stayed high for much longer, but it was an unexpected twist at the end of the term.
I wrote that the court had inadvertently released an order saying that it improvidently granted a case. They sort of bungled twice.
Hello? Oh, there we go. So I don't know, I assume most of you haven't been in the press room. It's a pretty tight room and we're all sort of pushed in together and we can all sort of hear each other talking, which, usually we're busy and I'm not paying too close attention, but I happen to sit right next to Greg Storer, who's the Bloomberg Supreme Court reporter. And I could tell that something was going on because there was a lot of intense conversations with his editor. And but I didn't really know what it was and I was focused on other stuff. And Greg, because it's a pretty collegial press corps, when the story posted, leaned over, he popped his head up under the cubicle and said, you should look at our website right now. And I did, and I like, oh, and so I refresh. Oh, that's what it was. And I think to Abbie's point, to Bloomberg's credit for putting the document online, because initially they didn't, and it was a bit of a challenge. I trust Greg, but sort of we put up a story almost immediately, just using the framing that Bloomberg had used, and I was comfortable with that. But it's really good to be able to see the document, and I'm grateful that they eventually put it up.
And what turned out to be the explanation? Do we know?
I mean, we don't know. I think all we can do is to speculate. I mean, one thing we do know is that, anybody, when they have an opinion ready, any justice can sort of pull back an opinion or dissent at any time. And so one kind of speculation is that they were ready to release it that day and then for whatever reason decided not to. And so it was sort of sitting there in the queue and wires were crossed, mistakes were made, and someone accidentally briefly pressed publish, but that's all we can speculate about.
Were there any changes from what Bloomberg saw and what we all saw? Was it one day later?
It was, yeah, so it's working. Okay, so we sort of ran it through a program to see if there had been changes, and there were some formatting changes, but I think that's just the way that Bloomberg had scraped the site. We didn't find substantive changes. Also, it was dated with the day it was accidentally released. So I think those are some clues that it was, and they released fewer opinions that day than they did other days. But of course, we can only sort of go by the context clues.
justices are always assuring the public that even though they dissent sharply from each other's opinions, they really all get along well behind the scenes. Justice Thomas has even referred to them as a family, if a somewhat dysfunctional family. Do you think it's true that they all get along pretty well behind the scenes personally, or not so much? Mike?
So I guess I think first it's pretty much beside the point, whether or not they get along. It's where they come out in the cases, of course, that matters. My sense is that this is not a court in which there are some, really warm and deep friendships the way there have been in past courts. I mean, Justice Breyer used to go on about Justice O'Connor a lot, obviously was quite fond of her. You don't really hear much of that these days. And for all of the talk about how the justices always say there's never been a raised voice and there's never sharp words exchanged, Justices Sotomayor and Barrett went out this past term and did a couple of public forums about how this idea that we may disagree, but we're colleagues and collegial. But in the course of that event, Justice Sotomayor said that there have been times where, something sharp has been said and someone has said, you really ought to apologize for that. So it's sort of, to me, it sort of like gave the lie to this idea that there aren't these very, intense exchanges, which is, I suppose, what you would expect when issues of this magnitude are being debated among people who have really very different ideas of what the law should be.
Yeah, I would sort of second the point that it is a little bit, maybe beside the point how warm their personal relationships are. When we've been out covering the justices when they give speeches, and I was recently covering Justice Sotomayor when she got an award at Harvard, and she said during that conversation that she, there are times when she would go into her chambers, close the door, and cry. And so that wasn't a comment about her colleagues, but about the substance and the impact of the decisions. And so I think that's really kind of, potentially where the focus should be.
Also, Thomas, we both covered Thomas. I was struck by at the Fifth Circuit this year, he several years ago, I think, told the story about how when he first got on the court, it was a very collegial court and how much of a family it was, and with varying degrees of specificity, sort of drawing a contrast to the current court. And when he did that a few years ago, it got a lot of attention and a lot of stories. This was before I was on the beat. He told the same exact story at this conference, was that a few months ago. And I think largely unprompted. I don't think it came in response to a question. He just went off on this thing again about how it was so much of a family before and now it's not. I was struck by that, him raising that, and also the Sotomayor comment about crying.
So you've already talked some about how you do your jobs, but let's talk about that a little bit more. What we see, reports on arguments and reports on decisions, must be the tip of the iceberg. What are you doing the rest of the time? Or is it a 2-day-a-week beat? Mark?
Well, it's obviously a beat with where preparation is everything. Getting, particularly in the spring, getting ready for decisions takes up a lot of time, and there's endless iterations, endless conversations about how cases might come out. And the bigger the case, of course, the more concern among my editors that we are first but also right, which raises the pressure a little bit. So that's what I spend a lot of the spring doing. And this time of year, of course, it's a different story. But during the year, there were so many big cases this term, across a variety of subject matter areas that there was sort of like no end to the stories, previewing cases before they were granted, previewing arguments, writing about what the substance of the arguments was, and then getting ready for the decisions.
Let me pick up on that, because I do think this is the kind of job where there's an awful lot of reading to do. And I find there's a whole series of subjects that I think I don't know anything really about. I mean, how many 16th Amendment cases have you written about it? But because they had a really big tax case that was about what what the income tax, what the 16th Amendment is and what the argument was and how that's been interpreted. Because it was really about this issue of wealth taxes, whether the government's going to be able to tax wealth or corporate wealth overseas. And so I find like when the court takes a case like that, I think, geez, what the hell is this about? And this seems like you're teeing up something for a conservative court, and they wanted the court to say that the income tax is limited to realized gains. In other words, you sell a stock, you wages, but you cannot, Congress cannot tax accumulated wealth. Anyway, so to make a long story short about one case, I find when I get a case like that, it takes a long time to like read and sort of understand what that's about. The case about opioids and the bankruptcy exception, I thought, that's a really big deal. It's a really big question there. And I think, I don't know anything about the bankruptcy code and and so I find that this job just requires a lot of reading and preparation. And Mark said, you can't wait to the day of the decision when they decide something and think, oh, I need to understand what they're, that's way too late because everything moves very fast now. So I thought there was like at least 20 big cases I was going to have to write about immediately on the day they decided. And sometimes I'd write about the argument. So anyway, I just find that the idea of saying, oh, well, they just decided the case is a lot in late June. What do you do the rest of the year? Well, there's a heck of a lot of preparation involved in that. And we also get a lot of these, Amy and I were talking about the last 5-6 years, a lot of these emergency cases where you have to, some sort of emergency appeal, and you really need to be able to read the lower court opinion, what the briefs are about, because the court's going to issue a decision that says yes or no. And that's not, again, you can't then say, oh, what's that about? I mean, so I just find that this job just requires a lot of reading and preparation. And that's how I spend my time.
And sometimes they all happen at the same time. And so the last week of June, when we've got all of these cases coming down, just to give you an example, the court was also fielding an emergency request from Steve Bannon to stay out of prison. And so at the same time that you're trying to get ready for all of the decisions on the merits, you're also reading about Steve Bannon and trying to stay out of jail.
And I think each case is sort of a world unto itself, like the tax case. You have to understand what the legal issues are, also who the players are. In that case, it was this couple, from Washington State challenging this tax bill. So who are they? Who is actually bringing the case? Who are the lawyers arguing the case? What are what are the broader implications for the country of something that seems very small, but of course it's not small. It's coming to the Supreme Court, and you can see by the raft of amicus briefs that all of these organizations are very interested in what's going to happen with the tax dispute with this couple, or homelessness. It was that case. That's a giant social issue that's played out everywhere, but largely on the West Coast. And you're seeing the justices try to understand what that looks like. So I think it's fascinating, and you can sort of go very deep into each case to try to understand it.
You mentioned amicus briefs, and the use of the filing of amicus briefs has really continued to grow. I saw recently someone mentioning that there had been 14 amicus briefs in Roe against Wade, 30 in Planned Parenthood against Casey, and 140 in Dobbs. Do you try to read the amicus briefs in important cases? Some of them, all of them, none of them? How do you pick what to look at?
I try to read the ones that I think are important. I will admit I don't get to all of them. I wish I could. Maybe I will in this new job. But certainly at USA Today, I'd read, the ones that I thought the justices were likely to ask about, or the parties that I thought might be, that might make stories, right? I mean, you can get decent stories out of the amicus briefs. just one that pops into my head. I did a story, I think, last term about all of the military amicus briefs. There were a bunch of military briefs in cases you might not think are have anything to do with the military. Probably one of them was affirmative action. I can't remember what they all were, but they were across 3 or 4 cases, like interesting briefs from retired generals, which I thought was sort of an interesting story. So you can get, I think, good stories out of those. And also, sometimes I find it's helpful to read the amici because sometimes they can say things that the parties can't say, or maybe somebody writes it in a way that's more clear. So yeah, I try to read not all of them, but the ones that I think are from really important groups or groups that have like an ancillary stake. Another thing for me is that you can sometimes get to real people in the amicus brief. So you can find people that are going to be affected by these cases who may be more able and willing to talk than like the named parties who may be more hesitant. And to Abbie's point, like, all of these cases, there are real people behind them. So there's good stories to tell, even when we're not getting decisions. There's good stories to tell about the people affected. It's why I like this beat. And sometimes you can find those people through the amici.
Another enormous pile of reading that the justices and their clerks have are cert petitions. Do you have time to read cert petitions to see what may be coming, or do you wait till there's a grant? Mark?
That's what John Elwood's for. John- No, John Elwood does the relist watch for SCOTUSblog, which highlights the petitions that are live and potentially about to be granted. But in all seriousness, I mean, there are a set of petitions that we see what's coming up at the coming conferences. So we know what's on the list of cases. And from going through that list, you can see the cases that, are of obvious interest because AP has written about them before, or they're just, major issues. So, there are some that get past us or me because, it doesn't on the surface raise any flags. The way the court grants cases at this point in time is it basically takes a look at a case twice before it says publicly that it's going to hear the case. So it gives us that time where most cases, of course, the petitions are denied the first time they're looked at. And there are a handful of cases that aren't denied, and those are relisted. And it's those cases that, of course, are the potential or likely grants. So it makes it easier to sort of focus in on what's about to be granted potentially.
Abbie, your bio on the Times website says that you write about the Supreme Court with a focus on the world of the court, including its role in politics and the lives of the justices. You examine how cases make their way to the court, the players involved, and potential conflicts, which sounds a little different from what most of the panelists probably focus on. And your background, as I mentioned earlier, has been really in investigative reporting. So what has it been like for you to come to a very different, or maybe not so different, job? How are you approaching it, and how is that working out?
Yeah, so when I joined the Times, I think they were looking for, Adam has, been on the beat for quite some time, and I think they recognized that they also wanted to sort of add some new dimensions to the reporting, not only because with emergency applications and just the number of cases that the justices are taking that are high profile, they wanted to add somebody else, but also because of questions about ethics of the justices, questions about sort of the transparency of the institution. And so I've been able to do some of that work, in the last year, reporting on Justice Thomas after ProPublica, I think a few weeks into me starting on the beat, they dropped their enormous story, which then of course led many of us, myself included, to focus in on court ethics. But, we've written about things as broad as the book deals that the justices receive. That's one of the carve outs that they have available to earn additional money that's not capped. And with Justice Thomas, looking at some of his ties through, we did a story about his clerk network, trying to help people, our readers and subscribers understand of the power networks that exist at the court and what is sort of a small world, but has enormous implications for all of us, and to help draw on some of that.
So I noticed one story you did involved a trip that you made out to Grants Pass in connection with the Grants Pass case. Was that useful?
Yeah, so the Grants Pass case, that's a homelessness case. The question was whether what this small town in Oregon had done in they had started enforcing this overlapping group of ordinances that essentially made it so that there was no place on public property where you could lay down and sleep with a blanket or a sleeping bag, anything like that. And so I had, maybe because I just spent so many years on the West Coast, I thought, this is such a giant issue. I had just moved to DC from Oakland, and it felt to me like I want to go to the town, see how this is playing out, and who are the people who are actually affected, who is actually out in the city parks. There had been a lot of local reporting about how people were outsiders coming into this town. But then when I was in the parks, just interviewing people, most of the people I interviewed had been in Grants Pass, if not their whole life, almost all of their life. Many of them were older, many of them had disabilities, and they didn't really have any place to go and they couldn't afford any housing. And so it seemed to me like there was a really rich story to be done about not only this town, but all of the towns where if the justices found that it was not cruel and unusual punishment, how policing could, be used to sweep people off the streets. And so that I felt like I really liked working on that story because it felt to me like we could connect something that's very distant from people, and then, actually tell the story through people who are experiencing homelessness, which I think is, one of the most important things that as a journalist, I hope to do.
David, I know you also wrote more than 2 stories about that case.
I have a lesser travel budget than New York Times did. And I said to one of my editors, how about if I get off the metro at McPherson Square and I'll write there. And so I did. I wrote a story about one of the things I found very curious about this case, both from the Supreme Court's point of view and the way the press covered it, is that the California and the West Coast states were under a rule that didn't apply in the rest of the country. How many encampments do you see on K Street or Mass Avenue or McPherson Square or down on the National Mall? If I were homeless, that'd be a nice place to have an encampment, but they won't allow you to do it. The police will say, you may not camp here. Muriel Bowser has enforced the DC laws saying you can't camp out on the sidewalks, and nobody thinks that's anything at all. They came and they put out a notice and said, we're going to sweep aside all the homeless encampments on McPherson Square. They swept them aside. Nobody went to court and said, hey, that's cruel and unusual punishment. You can't do that. They used the police and so I always thought there's sort of a very strange, so I wrote a story that basically says the law is different on the East Coast than it is in California. People in DC may not understand that. Sonia Sotomayor seems not to understand that, but the law is different here. You can use the police to clear the sidewalks and nobody thinks, oh, you're criminalizing homelessness. You can't do that. But that was the law. That was the issue in the case. The Ninth Circuit said, you can't remove these people, use the police to remove people from sidewalks because they have nowhere to go, which is a real problem. But it's also a real problem if, around Los Angeles where there are, I don't know what your neighborhood is like, but I don't think most people would think it's a great idea to have people camped out on the sidewalk in front of your house. You'd say, these people need somewhere to go. They need a place to sleep. They need shelter, but please don't camp in front of my house. So anyway, I just thought that was an interesting, big question. There was a great interest in California because of the Ninth Circuit rule, but the law was really the rest of the country wasn't operating. The Ninth Circuit was the only one that said this is an Eighth Amendment violation. So that's why I wrote about McPherson Square.
Yeah, and to that point, I think it was interesting to watch the oral argument because, uh, the justices, there wasn't sort of a California justice. It's not like this. I think the way that homelessness is visible here is quite different from in Los Angeles or San Francisco or Oakland. And so I thought it was just interesting to hear their perspective and the way that different justices were trying to think about homelessness because of the Martin v. Boise case, which is the underlying case to Grants Pass. The Ninth Circuit looked quite different from the rest of the country.
So Abby, with your large travel budget, are you going to go back to Grants Pass in a couple of months and see what the Supreme Court has wrought?
Yeah, so there's I've been talking with another reporter about sort of how we can keep following what's happening in Grants Pass. The day of the decision, the people who there's a nurse who goes out to the homeless encampments in Grants Pass, and I was on the phone with her, and she was passing the phone around to the different people who I'd interviewed when I was out there. And I've been texting with them and keeping in touch with them. Oregon is different from California in that there's also a state law that is protective, and so. So far, as far as I know, they have not swept the encampments. They have more protections than they would if they were farther south.
Another small addendum on that. LA is different than San Francisco. Los Angeles the mayor does not want to use the authority to sweep. She's very much opposed to that. San Francisco wants to use that authority. So it's even in California, it's going to be very different depending on what not all the mayors are going to say, hey, let's send the police, because they don't think that's a good idea, and they're not going to do it.
I think you also need Abbie to investigate Honolulu. I think that's really important.
Definitely, all over the Ninth Circuit.
It's a big problem in Honolulu. Yeah.
Yeah, well, and speaking back to amicus briefs, that's one of those cases where maybe we didn't read all of the every word of the briefs, but you can see even when there was a push to grant cert in the case that Gavin Newsom was weighing in, pushing the justices, please take this case, and that's not traditionally, like, you just saw sort of unlikely alliances between conservative groups and more liberal groups or political leaders. And you could see that play out in those briefs.
So I'm going to drag you back for a little bit to decision days and reporting on decisions. When decisions come down, as several of you have mentioned, you want to get some news up pretty quickly. And one way to do it, probably most people in this room have looked at Supreme Court opinions, and the first thing you see is the syllabus, which is a summary of the facts and the holding in the case, and has a lineup of the justices at the end. But what do you do when you see a lineup like this? And I found a good one for you all this year, I think. So this was a case called Vidal, if I'm pronouncing it right, against Elster, which was the case in which someone tried to trademark the phrase "Trump too small" to put on T-shirts and baseball caps. And the question was whether that violated a provision of the Lanham Act, the Trademark Act, that says you can't use the name or likeness of a living person without that person's consent. The question was whether that provision is constitutional. But you get to the end of the syllabus and it says, Justice Thomas announced the judgment of the court and delivered the opinion of the court except as to Part 3. Justices Alito and Gorsuch joined that opinion in full. Chief Justice Roberts and Justice Kavanaugh joined all but Part 3, and Justice Barrett joined Parts 1, 2A, and 2B. Justice Kavanaugh filed an opinion concurring in part in which Chief Justice Roberts joined. Justice Barrett filed an opinion concurring in part in which Justice Kagan joined, in which Justice Sotomayor joined as to Parts 1, 2, and 3B, and in which Justice Jackson joined as to Parts 1 and 2. Justice Sotomayor filed an opinion concurring in the judgment in which Justice Kagan and Jackson joined. So you look at that, and what do, Mark?
Well, I'm sure everyone has figured out that it was a unanimous judgment in that case. There were no dissents. There was there were a lot of opinions. And seriously, that's sort of what is sort of what we expected when the case was argued months and months earlier. It seemed very clear that the guy who wanted to trademark Trump too small was going to lose. And it was a big mystery why it took so long. And it took so long because everyone had something they wanted to say about, doctrine and about the use of history and the First Amendment. But the outcome was unanimous, and and it was easy to discern that, and that's what I wrote about. To be perfectly honest, I mean, it's an interesting topic, and the use of history, to interpret the First Amendment is an interesting subject, but not what I was immediately focused on.
Not the first take. I mean, I think the first few seconds we're getting a story up on who won. And while that was a very complicated vote line, as Mark notes, there were no dissents, so that was pretty easy. I may have held off on putting a vote count on that story first take. I can't remember, but the way it came out was clear. The one that actually bothered me a little bit more were the net choice cases. These were the social media cases and the law in Florida and the law in Texas. Similar laws, but slightly dissimilar, dealing with can states essentially regulate the content on these platforms. And that one was also relatively clear what they were doing with it. They basically punted on it. They said they didn't like the analysis that the Fifth or the 11th Circuit did, take another look at it. But the thing that wasn't clear from the syllabus in that case, at least to me, maybe to my colleagues it was there was this discussion later in the opinion, deeper in the opinion, about content curation by these platforms being protected by the First Amendment. To me, that was sort of the heart of the case. It was very important. And I couldn't get into that in my first story because the first story was we just threw up a quick, these cases are going back. I think we called it a punt. We did get it in our first take that the laws would be blocked while it continued. So that was important. But because of the way we have to do our jobs, the speed at which we have to move, and if the syllabus or first few paragraphs of the opinion aren't clear, sometimes I feel like we miss important context like that. That's a case that I a little bit regret not having more time with before I put the first version up. We got there eventually. I mean, within 30 to 40 minutes. Of course, I think that was the same day that immunity landed. And so we were entirely focused on immunity. And those net choice cases got a little bit short shrift. We got there eventually. But the first take was lacking a little bit because of the way we have to move so quickly, at least for me.
May I ask a question before I give a poor answer? How many of you guys are interested in the court and law? And they issue decisions, at 10 o'clock. How many of you would say you look up and look for the decision and the result within the first hour of, say, from 10 to 11? Do most of you or just some of you do that? So some, but not more than half. Because I think we all operate on the assumption, it's the operating assumption, it may not be right, but that everybody is, you've got to get this up in 15 minutes or 20 minutes or you're lost. No one's going to read your story. So there's a great pressure to get up stories very quickly. I think we all operate on the assumption, as I say, which may not actually be true. But I think, Art, when we talked about cases, there's a whole lot of cases you can prepare that are sort of a yes/no question. They're going to affirm or reverse, and it's pretty simple. And this one, the Trump T-shirt case, was a yes/no case, and this guy was going to lose. Everybody knew that. And so when you're preparing a story, it's easy to prepare a story that if you know the outcome, and the fact that there's 8 different concurring opinions, who cares? I mean, it was a fairly simple yes/no case. There are a fair number where they're really divided, and that you have to pay attention to the syllabus to say who voted for what and what. But those are few in number. Most of the cases, you can sort of count the votes, see who won, and it's pretty straightforward and simple.
And do you take the time after your initial simple yes/no affirmed reversed report, how much further writing and revising do you do in the course of the day or even more than a day?
I know all these guys do some, everybody does. I try to put up a headline, a lead, 2 or 3 sentences. I'll say it was a 6-3 vote. They said this, the dissenters said that. This is a big deal for this reason, and then background. And then 30 or 40 minutes, I try to put up a revised story with some quotes from the majority, quotes from the dissent. maybe a quote from React if somebody has a really, and then I will revise it again. So I think I'm interested what the rest of, I think everybody, nobody stops with the first story in 10 minutes and say, oh, I'm done for the day.
Yeah, I would say it's sort of rolling throughout the day. So initially, yes, the vote count, if there's a clear vote count, what happens to, what's the practical effect? Try to get that up right away. And then fully reading, pulling quotes, and then trying to get, concurrences, dissents, and reaction from, if it's a political case, political leaders, if it's trying to get reaction from the parties and we just I just keep writing all day, basically, just writing through and through and through and I actually feel like it takes me a while, maybe, after years and years of doing it, you get way faster, but just to kind of sit with the decision, I feel like by the end of the day, I'm fully immersed in it, but it takes me a little while to feel like I get kind of the nuances, or it's just to do a story that I feel like is fully complete does take me a while to get immersed in it.
I think that's a little different for television, which I'm still learning since this is my first term in TV. I write a lot for digital. One of the things Mark mentioned, how we are having to sit and write live blogs for arguments, which is definitely true. And it's changed the way we cover the beat. We are now doing live blogs for opinion, some of us. And so there's increasingly less, like for CNN, my pre-write that I do, I write it weeks or months in advance. That goes up. But the thing that's really promoted on the homepage is a live blog where an editor disaggregates that story and puts it into little posts. And then further, after we get the opinion, sometimes I get a chance to rewrite the first draft, and other times we're doing a takeaways, which is a thing that the Google algorithm really likes. And I also think, to be fair, readers like, right? Give me this opinion in 5 chunks. Tell me why it matters in 5 chunks. And then usually I think all of us, if it's a big opinion, are trying to do like a day 2 story as well, sort of something sweepy or an impact. So I find that just like the main bar on argument day, sometimes it's not getting as much attention. I find that on opinion day, sometimes my main bar is getting less and less attention for all these other products that we're giving people to see. And I think maybe you get there in the end, maybe it's the same thing, but the actual main bar I spend less time on than I used to.
So if David had asked for a show of hands of people who want to know instantly what's happening, people who raise their hands would all be going to SCOTUSblog or Howe on the Court and watching Amy's live blog. I actually didn't know you were also doing a live blog. And I sometimes do that. And I imagine you have a pretty big audience at the end of the term. How do you, since they don't do a live stream of the decisions and you can't take a device into the courtroom, how do you manage to do a live blog from some remote location?
So I try pretty hard on days that the court is issuing opinions. It's not that different, I think, a process from any of these folks to be in the court's press room, partly because I don't want to count on either my Wi-Fi at home or the court's website to be releasing, to have access to the opinions online at any particular moment. The website is pretty good about getting the opinions posted right away, sometimes a little too good about posting opinions. But so I'm sitting in a seat in the court's press room, and the court's public information office is right next door, probably maybe 5 or 6 yards away. And so a couple of minutes before 10 o'clock, all the reporters line up over there, and there's a loudspeaker that has the proceedings in the courtroom. So when the court is gavelled into session, we can hear that, the Chief Justice, the Associate Justices of the Supreme Court of the United States, the sort of oyas from the Marshal. And then the Chief Justice will say, Justice Barrett has our opinion in corner post. And at that point, the folks in the public information office start handing out copies of the opinions. And it's a little bit of a mad dash as everybody grabs them and goes back to their desks. And so then I hop onto our live blog and start typing about the outcome of the opinions. And that's essentially my first story of the day is, writing on the live blog about the holding and the outcome in that particular case. Justice Barrett and Justice Kagan in particular, I think, we all love it when they have opinions because they are very clear writers generally, and they are also very good for the most part about putting in like a little paragraph at the beginning that says, this is the issue in this case. The answer is, essentially yes or no. Sometimes some of the other justices will sort of say, this is the issue in this case. The answer will be on page 12 of the opinion, and you have to sort of leaf through. So.
I think Amy does a great job and sort of a service to everyone, to people who follow that. Because her stories are, she knows the law, she knows the cases, she states it clearly. Because there's always a potential for a lot of editors or even reporters to get the very wrong view of some case at the beginning. And I think Amy and AP have always done a great job of being reliable and quick on the days of decisions.
And do any of you have to fight sometimes with your editor who wants a story up right away and you have to say, gosh, I just don't know yet. I can't do it this fast?
One of the things I always tell my editor, and he goes along with it, I said, look, we don't want to be the first up with the wrong decision. There's a great opportunity to make a fool of yourself by putting up something and then you realize it's wrong. So I think, I can't speak for others, but I think most editors would like you to move fast, but they want to make sure I will say that I was talking with you earlier and the rest of the reporters. I thought, as I said, most of the decisions are sort of an easy yes, no, but some of them are not. And the immunity case was a good example of one that was not an easy, you knew it wasn't good because there was a great, from no immunity to total immunity. And it looked like they're going to be somewhere in between, but where in between and where they, and so that one was a very hard, you knew it was going to be, but it's a very hard opinion to take up and say, oh, Trump won or Trump, you couldn't, you had to actually see what they said. So those, I think, are a real challenge if you're under pressure to file something quickly, but it's a 38-page opinion with a 30-page dissent and a concur, that one was hard to do fast.
Are you under any less pressure because most of your audience is not awake yet at 10 a.m. Eastern time?
I don't know who our audience is, and I'm not sure whether they're awake or asleep. I don't let it bother me one way or the other.
So this term, there were 7 oral dissents, which is the most I can remember in a term. And I guess you can hear them in the press room, but not if you're working from home, for example. How important are they to your story, either right away or as the day goes on?
So the oral dissents, when the justices read from the bench, it's a rare and it's a sign of, sort of profound disagreement. And so, I don't know how everyone else thinks about it, but we always try to note in the first few paragraphs when that's happening, and definitely mention it, and then also try to give a sentence or a clause at least explaining for readers, like, this is a big deal, this doesn't happen in every case, and it's just a justice dissenting and emphasizing their dissent. And so it's always part of the story, and it's something that I think if they would live stream their opinions, that the public would have sort of a greater understanding of what that means.
I think the one thing that was sort of particularly notable about the oral dissents this term was the Justice Jackson oral dissent in Corner Post, which is a case about the statute of limitations to bring a lawsuit challenging an agency action, which doesn't really strike you sort of in the abstract as something that would spark a dissent from the bench. But one of my colleagues noted that this was like each of the 3 liberal justices had an oral dissent in one of the administrative law cases this term. Justice Kagan dissented in the Chevron case. Justice Sotomayor dissented in the Jarkissi case.
Yes, yes.
And then Justice Jackson dissented in the Corner Post case. And it was sort of, perhaps there was some strategy involved on their part to sort of draw attention to this area of the law that it might not have otherwise gotten.
Abbie's right that the dissents are unusual enough that it's always worth a mention that they're being read aloud in the courtroom. But almost all the time, what the justices read from their dissent, you can find in the opinions that they've written. Every now and again, though, a justice will go off script, and that's often the most color you'll ever get out of a Supreme Court session. And the one that comes to mind is way back in 2007 when Justice Breyer dissented in a school race case, in which he said about his new colleagues at the time, Chief Justice John Roberts and Sam Alito, and then the rest of the conservatives, never have so few done so much in such a short amount of time. So that was a moment of high Supreme Court drama from an oral dissent.
One justice who had no oral dissents this term was Justice Barrett, and yet from several of the stories I've read, she seems like she may be center stage in this term's news. David, do you agree with that?
Yes, I do. I think she's the one who, on the conservative side, who's in the business of law, not politics. And the thing I wrote a story about the immunity case. John Roberts in the past has been the kind of person who's wanted a sort of middle ground position, particularly on the big controversial partisan cases. That's sort of his, we're a court, we're not partisans. And Amy Barrett had set out a view. She thought there was no need for this broad talk about immunity. She thought the immunity was quite limited. We ought to decide the case before us. John Roberts made some comment about we cannot afford to fixate on present exigencies. And I thought, what the hell is that? I mean, we're not going to decide the case that's before us. We're going to pontificate about presidential powers and how they could be used. And so I thought Amy Barrett had a reasonable view that the conservatives could have joined with. Yes, there is some official immunity for core powers, but most of this indictment is about some private scheme to upset the electoral votes. And that's not an official duty. Why don't we say so? Why don't we say so and allow the case to move forward? And nobody else went along with it. And on the case involving the insurrectionists who broke into the Capitol, the law seems to say corruptly obstruct an official proceeding. And John Roberts said, no, it couldn't mean that. It means documents. It doesn't mean, and she said he had to do textual backflips to ignore what the law actually said. And so she would have actually voted, had one other conservative gone along with it, to allow the charges to proceed against those who broke into the Capitol. And she would have narrowly allowed Trump to win in part and lose in part on the immunity case. I thought the court would have looked better. The country would have been better. Unfortunately, nobody on the right, John Roberts was not interested in a reasonable middle ground position.
Well, Justice Jackson was part of the majority in the insurrection case too. So it would have taken more than one conservative. Justice Jackson, who we mentioned only briefly. I mean, she was in the majority in that case. She also, in some sense, I mean, it was a 5-4 decision, so they were all the decisive votes. But she was the last person in the room to vote, presumably, when they decided to knock down the opioid settlement, the multi-billion-dollar Purdue Pharma bankruptcy case. So that was sort of a kind of an interesting role for her to play. Just about Barrett, I do want to say, I mean, I think it's undeniable that on a couple of instances this term, she sort of, distinguished herself from the other conservatives. But, she was clearly with all the conservatives in all the administrative law cases In the redistricting cases, she was with the conservatives this term in a majority, and last term in dissent, when even John Roberts and Brett Kavanaugh were on the other side. She was a vote to overturn Roe. She was a vote to end affirmative action. She was a vote to expand gun rights. She was a vote to against the a vaccine mandate for healthcare workers in dissent, when even John Roberts and Brett Kavanaugh were in the majority. So I just think we don't want to overstate sort of how far Barrett has moved or is moving, although she did have some interesting votes and interesting opinions this term.
Yeah, I would just add, I mean, I think she is really interesting to watch on the bench, and how active she is in the arguments. And I think in the EMTALA, the Idaho abortion case, she was particularly interesting because, the three liberal women had all spoken, and then she seemed to sort of join them, in her questioning of the lawyer for Idaho, on what the exceptions would be, and she seemed shocked by sort of the lack of like gray area in the law for women who had, might lose organs but might not die. And she seemed really kind of shocked and surprised by that. And so I think her voice, I think it would have been quite something to have a gender divide in that case if that had been the way it had come out. And so I think she's certainly very interesting to watch, and not as predictable as, maybe it would have seemed when she was first confirmed.
I agree entirely on.
So all of your outlets have done end of term roundups, talking about the most important cases in the term. And it was interesting to me, the choices that some of you made. I've got a couple of questions in comparison. And so this is a question for Abbie. Everybody else put the bump stocks case in their top cases of the term. David put it number 4 in his list, and the Times didn't put it in their top 13 at all. Now, I realize you are not the only byline on that story, and so don't feel you have to defend someone else's choice. But why did the New York Times think bump stocks was not one of the top 13 of the term?
I would say it's an art, not a science. It's not, we were just kind of going through which cases might have the sort of broadest impact. And that case, it was the machine gun case about whether a bump stock attachment to a gun turned it into a machine gun. And so I think part of the thinking might have been it's not a Second Amendment case like Bruin or Rahimi that could change sort of constitutional doctrine. But I think we could have, I don't know that there's a great answer. We could have included it. I certainly thought it was a really interesting case. I covered that case, and it'll be really, I'm very curious about whether bump stocks, which I think had been somewhat obscure before, before the Las Vegas massacre, whether those actually, now become used by a lot more people because there's been so much focus on them.
So I have an opposite sort of question for David. On your top 10, you included Snyder, the case about whether federal law criminalizes bribery of state officials. And nobody else had it in their list of top opinions. Why did you choose it?
Well, I thought it was a good term for corrupt public officials, and And we're saying, so if you, are a mayor of a town and want to take a big payoff, for somebody you've directed $1 million contract to, the court says, go right ahead. For 40 years, the law had said that you may not take a payoff of more than $5,000 to be influenced by or rewarded for an official transaction. And the court essentially wiped that out. It was the oddest argument. It was a little bit like the one I mentioned about we don't want to be fixated on the present situation. They were asking questions about, well, what about a person who gets a framed photograph or a free lunch? Look at if we open this up, there's going to be all these gratuities. And I thought, they had nothing to do with free lunches. This is a mayor who went to these guys who he steered $1 million in contracts to this company that was going to deliver garbage trucks, and went in 2 weeks after the contract and said, I want a $15,000 payment. And they agreed, okay, we'll write you a check for $13,000. We'll call it consulting. And he gets prosecuted, convicted, and the Supreme Court reverses and says, no, rewarded doesn't mean rewarded. So I wrote a story about that. I thought, boy, this is a crowd that's sort of under the gun for corruption. But at every term, they seem to find a way to upset somebody's public corruption case. I remember coming to this meeting a number of years ago and making fun of the decision about the former Virginia governor, Bob McDonnell. He takes $175,000 in gifts, all sorts of gifts from some guy trying to promote some tobacco product. And all he did was set up meetings in the governor's mansion, did all these promotions to help the guy. But the other people in the state wouldn't go along with giving some money to state action to the promoter of the and so the Supreme Court reversed his public corruption conviction because sure, he took all these gifts, he did all these things, but what's a couple meetings in the governor's mansion? And I said, geez, if I was writing I had no idea that constituent service worked like this. I live in Virginia. If I have something that when I sell, I'd like the governor to have a meeting in the Oval in the governor's mansion in Richmond so I could promote it. Anyway, they're sort of soft on public corruption, and I thought I'm going to play up that case. You're getting a lot of recognition, Art. This is an editor who took all the stories that I'd written and put them in his view about what are the top 10 lists, and it was his judgment call. I didn't disagree with it, but it's totally arbitrary. Is the homeless case number 5 or number 3 or number 7 or whatever? It's just a judgment call.
Well, speaking of ethics, there weren't such blockbusters this term as last term with the stories about Justice Alito's fishing trip to Alaska and Justice Thomas's vacations in Southeast Asia. But there were continuing stories about ethics, including Mrs. Alito's flags and Justice Alito's comments that he didn't know were being recorded at a Supreme Court Historical Society event. And I think ethics has been an important part of your beat, Abbie. What's the latest news?
Oh, who knows? The justices are probably on their vacations now, so we will see where they are and what they're doing.
About 5 years from now.
No, I think, yeah, you're right that last year, especially with the stories about Justice Thomas, Justice Alito, that it was extraordinary, the reporting and what came out from last term. But this term, yeah, we did have, the stories. Jodi Kantor had written the stories about the flags that the first upside down American flag, the flag that flew at the Alito's beach house, and sort of what that might signify. And then there was the Supreme Court Historical Society, which the Times had written about for other reasons previously at their gala. The woman who described herself as a gonzo journalist or an advocacy journalist who had secretly recorded Chief Justice Roberts and Justice Alito and Martha Ann Alito in their conversations. And so I think, I don't think this is the end of the reporting. I think that we will continue, we'll continue to follow any leads that we have. I think one of the things that was, and I don't know how everyone else feels about it, but when we were trying to decide how to report on the secretly recorded conversations, that's not a tactic that we would use. I wouldn't use it. I would not have done what she did to get those conversations, to go into the gala not as a journalist. We'd actually asked to go to the gala and we're told we couldn't go as journalists, and that to go we would, we could go as ordinary people. We could pay for tickets and become members. I think it was $500 or something for, I can't remember if it's the ticket, and then 150 or something like that to be a member, something like that. And we did not do that, because when we go somewhere, we're going as journalists, anybody, from the Times to report on something like that. But we reported on the conversations. And so there are always discussions about how are you going to report on something that you actually wouldn't have done as a journalist? And so, in my story, I tried to include, journalism ethics experts talking about, their guidance for reporters on that, looking up the laws on, one party, two party states, trying to get some kind of context about to put it in. But I think it's sort of tricky to figure out how to report on something like that, which is newsworthy. But it's definitely a path that we wouldn't have taken.
Did it? Yes.
There were calls, obviously, for Justices Alito and Thomas to step away from cases this term, all the January 6 related cases, Trump immunity case, and also in Justice Alito's case, the wealth tax case. And Justice Thomas, which has essentially been his practice, basically ignored the calls. He never said anything. But Justice Alito, like what he said or not, he did provide two written explanations for why he wouldn't recuse from either the case involving, because of the flags that his wife flew, or the case involving the wealth tax because of his connection to one of the lawyers in the case, which at least as reporters gives us something, something tangible to say about the call and the reason why he's rejecting the call.
Where it's 10 minutes of 2, I do want to leave some time for questions. If anyone's ready with a question, you can stand up and ask, and if not, I'll ask a question to the panel while you're thinking. I see a hand in the back corner there. John. Why is the court taking so few cases, asks John Elwood. No one knows? Do you have an answer, John?
I was curious if you thought that the emergency applications have anything to do with it. We're seeing, emergency applications quite frequently, and the justices have to sort of decide quickly. Do you think that increase in those might have anything to do with the hesitancy to take more cases?
I thought so in the past, but we had less of a shadow docket this year, and yet it was still a low number of grants. And one thing I've thought about is Justice Kavanaugh has said at like the 8th Circuit Judicial Conference or something that they're kind of pre-gaming about whether they can come to whether they can provide a definitive view, and they're not taking the cases where it's kind of marginal. But I don't have an idea. So,
They do
I will
have.
repeat the speculation I've had.
They do for this coming term have, so there are, I think, 32 hours of arguments available for October, November, and December, if you argue 2 cases a day. And they filled, I think, all but about 5 of those hours, which I think is a little bit more than they've done in the past couple of years by this time.
Do you think some of it is just they feel, even if they're not taking that many cases, they just feel really busy because they're all writing so many separate opinions? I don't know, I'm just kind of spitballing.
I thought you were going to say books.
Also true.
They did set a record for concurrences this term. And why is that? Is that they just can't help having to add their own 2 cents? Any other explanations? No, all right. Other questions in the audience? Way over here. So is the chief trying to rein in other justices behind the scenes? Any gossip? Sounds like no one has a good answer for that online questioner. Someone else in the room? Yes, ma'am.
Can you speak to which of the justices now or in the past, whose writing you admire or just enjoy reading the most? And why?
All right, whose writing do you admire or enjoy and why? Current court or the past? Open question.
I mean, I would start, I think, with Justice Kagan. I think she's just incredibly clear and also, I think, writes in a way that's easy for people to understand, including lay people. I think, sometimes I think she'd put us all out of a job if everybody wrote as well as she did.
I agree 100% on Kagan. She's smart and she has a conversational style. She's like writing like she's talking to you. I think I also think I'm in the minority on this. I also think Gorsuch is a very good writer on a sort of big picture things. Somebody asked about concurring opinions. He wrote an opinion that's a concurring opinion to the Chevron case that really tells you, I thought, in an interesting way, his whole view of where the court went wrong on Chevron. And he's got a lot of examples of like immigrants cases and of veterans cases. And his view is that the Chevron doctrine was the government's always right. And he had a series of, anyway, I found it there's a number of times where he writes an opinion and I thought, geez, I didn't think that made any sense. But now at least I understand his big picture view. He likes to write these big picture views on some area of the law. Brett Kavanaugh writes these very practical, conservative, sort of, he tells you, here's the three things we didn't decide, or here's the three things this opinion means. He's a very practical oriented guy, but Gorsuch loves to write these big opinions, sort of thinking through a whole area of like the Establishment Clause or whatever. So I find him he's an interesting writer and an interesting thinker and different from, I read him because as I say, he frequently has a view that I hadn't even heard before, and he sort of spells it out in a smart way.
Yes, sir. Question for those who couldn't hear about stays of execution. How has that changed, if at
Well,
all?
I mean, I think it's a fact that there are many fewer stays granted. I mean, the majority made clear a couple of years ago that, forgetting the exact language, but that they weren't going to tolerate what they perceived as, 11th hour gamesmanship on the part of defense lawyers. So there haven't been that many. I mean, there is a case coming up, going to be argued in the fall out of Oklahoma, the Glossop case, where the court has granted a stay. It's actually, I think, the second or third time the court has granted a stay in that case, but it's very much the exception these days.
1:58, we've got time for another question.
One more.
I think I see a hand. Yeah.
I tell you, this has truly been an exhilarating day for me. Quite frankly, there's no more important place to be than right here. But I am curious about how you feel about this question. Over the last 7 years, you've been called enemies of the state. Now, if there is a change, I mean, what is your plan of action? I mean, someone pulls you out of the house at 1 o'clock in the morning, you're not going to find any support at the court. I mean, What are you doing about that? The other thing is, there's been, it seems like things that we were told in law school, filing of frivolous lawsuits, stare decisis. I mean, if you file a frivolous lawsuit, that could be the end for you. But now it seems to be routine. I mean, can you talk to that? I mean, there, at least for me, there just doesn't appear to be a lot of emphasis on that. I mean, there may be some mention, but it seems to be more casual than it is emphatic. And David, I will tell you, every time that you open your mouth today, you put goose pimples on me. Thank you so very much. I thought this was dead. I mean, you're looking over your shoulder if you have a contrary. So refreshing to hear.
Any reactions? Do you all have your lawyer's number written on your wrist?
Don't have goosebumps.
As to your first point, I don't know that I have a reaction other than we're just gonna do our jobs, and that's, I think, you know. I would say to the second point that something, having gone through law school and then seeing some of the cases, one of the cases I thought was really interesting to watch this term was the abortion pill mifepristone case. And then to try to explain the underpinnings of that suit, what the organization was that brought the suit, who the doctors are who joined it, and then to wrestle with how to explain how that lawsuit made its way to the Supreme Court, after taking classes talking about standing, I thought it's just really interesting to watch how that case unfolded. But ultimately the justices batted it away and did find that they didn't have a direct injury. There wasn't, in fact, actually a claim that the doctors or the groups could make that satisfied the justices. And so I think it is interesting to see those kind of cases make it, as we say, like all the way to the Supreme Court, with those kind of factual underpinnings.
Well, I've got lots of more questions, but it's 2:00 and you all have to resume billing. So we are at an end. Thank you all for coming, and thanks to the panel.
Attendance and for your engagement. Look out on our website for upcoming events. Thank you so much to our journalists, particularly the new folks. I hope you will come back because isn't this a whole lot of fun? And thank you, David and Amy, for being the voice of consistency over the years. We really appreciate all of your very hard work. Thank you all. Have a great day.